NBC News correspondent Gabe Gutierrez, who is in Minneapolis. We also have retired Seattle Police Chief and MSNBC law enforcement analyst Carmen and former U.S. Attorney and former FBI senior official Chuck Rosenberg. Everybody welcome. Chuck, I do want to start with you. The points we heard the defense making at the end there, showing that image of what a restraint looks like with the knee on the shoulder and across the individual, the arrestee's neck, and then showing Derek Chauvin, it seemed like the defense scored some points there.
Yeah, actually, Katie, I think Mr. Nelson's cross-examination of Lieutenant Mercil on use of force was one of the more effective cross-examinations that he did. What he's trying to do is elicit some reasonable doubt. And he only needs one juror to agree that there's reasonable doubt. Remember, we've talked about this, I believe. You need 12 jurors, unanimity to convict. You need 12 jurors, unanimity to acquit. But to have a hung jury, a mistrial, you only need one juror to agree that what Chauvin did under the circumstances was reasonable. And so the cross-examination by the defense attorney, Nelson, of the use of force lieutenant, Mercil, simply tried to show the jury that while the policies in black and white in writing may be reasonably clear, in real life they're more complex, they're more nuanced, and that there are exceptions or occasions when an officer sees or does something that might be appropriate under circumstances not fully contemplated by the written policy. That's all he's trying to do. And I think to your point, he did it reasonably well. This is what defense attorneys do. This is why we pay them to do what they do. They try to introduce reasonable doubt. Whether you like it, whether you don't like it, Mr. Nelson is simply trying to do his job by his client.
Chief Best, I want to talk about the crowd because the defense keeps going back to the crowd and trying to make the point that the crowd was dangerous and that the officers involved were both distracted by the crowd but also threatened by the crowd, and that's why they remained in the position they were in. There was also the traffic on the other side of them. When you look at the images of that crowd, and there was one where somebody was being held back, it appeared to be at least, what would you suggest to your officers when you were chief, how to deal with a crowd like that in a situation like this?
Well, officers deal with crowds like that often, homicide scenes, large gatherings where the families get into domestic violence and each side is fighting. So we often are at calls, almost every call, where there's a potential for onlookers or bystanders to be aggressive. In this particular case, people were more or less pleading for the officer to get off of the neck, back, shoulder, whatever, the argument's there, but to get off of Mr. Floyd, and because he was being passive and was saying that he couldn't breathe. So I saw more of that than anything. Obviously, we always want our officers to be alert, to be mindful of officer safety. This situation does not, elevate to that high level of threat to officers. And I think any officer would tell you that. You go into any situation, of course, there are going to be bystanders, onlookers, and often people who have high emotions. So you're going to be aware of that. But certainly that doesn't call for what the defense is trying to say is some aggressive crowd. I mean, I can tell you that, I've been in crowds where there have been truly aggressive crowds throwing rocks and bottles and doing a lot of other things. So we want officers to be aware, but that wasn't the case here. So I find that to be more of a distraction than an actual concern.
What about the argument, Chief Best, that the defense is making that there's a gray area between what you're trained and what real life is like, and that they do teach officers to make individual decisions, to use their best judgment? How as somebody who worked in law enforcement for so long and who oversaw a force of her own, how do you explain that to the general public who, isn't in those situations?
Yeah, it's true. We do want officers to use good judgment. That's the reason we have so much training and retraining and refresher training. to make sure that officers are using the best training possible to make the best decision possible for the circumstance that they're in. That said, even as they're talking about the use of force and where the knee was placed or not, it is unreasonable in most people's view for someone to remain in that position for the length of time that former Officer Chauvin did. That's my own experience. I, too, myself, have had to arrest people and take people into custody with several officers assisting and hold them down until we could get the situation under control. This is not an unusual circumstance that officers come across. But immediately when the resistance is minimized or done, then you move the person to the recovery position and make sure they're okay. You're responsible for that person and for their safety and welfare, particularly when they're handcuffed, more so than any other time. So I would say that we do expect officers to use discretion and to use it wisely. We try not to speculate or second guess every little decision, but in a circumstance like this, where 1, 2, 3, 4, 5, 6, 7, 8, 9 minutes go by, we would expect a different reaction than what we saw.
Gabe, let's talk about what happened this morning and the other gentleman who was in George Floyd's car, Morris Hall. The defense wants him to testify. He does not want to testify. What more can you tell us about that?
Katie, I'll get to that in just a moment, but would actually want to begin with some new reporting that we got from inside the courtroom from one of the pool reporters that we just got a note from a few minutes ago. So you were talking with Chuck and Chief Best about the testimony so far today over the past hour and a half about use of force. The question is, Katie, whether that is landing quite so much with the jury. We just heard from the pool reporter that about an hour and a half ago, one of the jurors appeared to be sleeping. About 45 minutes ago, several of them, only one of them was taking notes, but several of them were looking around the room, seemingly distracted. So, Katie, this is something that we perhaps expected today with some drier testimony than what we saw last week with all the emotional bystander witness testimony, and then yesterday with a high-profile testimony from the police chief. So it appears some jurors are having trouble concentrating or at least getting a little distracted by the testimony we saw today. Now, switching to what you asked me about, which is earlier today there was a motions hearing before the jury was brought into the courtroom, and that has to do with Maurice Hall. He is the friend of George Floyd who was in the passenger seat of his SUV, and through his attorney today, he was arguing that he should not be compelled to testify, that the subpoena for his testimony should be quashed. That's because he says that he will invoke the Fifth Amendment and will not testify because, his attorney says, he will likely be asked about whether he provided drugs to George Floyd, whether he provided the counterfeit bill to George Floyd, and he does not want to be implicated in any potential future prosecution for, say, third-degree murder. Now, the judge came back and said that he wants the defense attorney to limit the scope of questioning and to draft a list of questions, very limited. For example, what was Floyd's demeanor when he was inside the SUV? They are now going to discuss that on Thursday.